Within the patent litigation practice group at Mintz Levin, we, like our peers, were very interested and concerned about how profound an impact the American Invents Act and the patent reform that came with it, how profound of an impact that would have on our marketplace. Certainly within the political climate, we thought that it would be significant, and it has been. And one of the most significant attributes has been the number of cases filed under the new inter-parties review process, but not only the volume of the cases, it's been the results, with a very significant, a surprising number of patents being killed or rendered unpatentable. And so we at Mintz Levin were very interested in how patent holders' rights were being treated within the new process. And we were brainstorming about what could be the possible opportunity and mechanics for trying to visit what we thought were some of the infirmities that were coming out of the decision-making in the new process, out of the patent board. And our client, Straight Path, luckily enough, presented us with an adverse final written decision they had suffered at PTAB. We looked at the administrative file, and we saw a significant claim construction issue that we thought the board had simply got wrong. And while we understood that the task was daunting, we thought it presented a good issue. The problem is that because of the volume of inter-parties review cases being filed, the Federal Circuit had quite justifiably kind of stayed clear of stepping in unless absolutely necessary. And so we were struggling to figure out the way to present the issue in a way that would attract the Fed Circuit's attention. Thankfully, we did, and I think the successful outcome, which was for the first time, a full reversal and remand of a PTAB final written decision, not only is an excellent result for the client and an excellent result for our practice group, but I think it shows that in the continued evolution of what patent reform is in America, the Federal Circuit is going to become actively engaged in the PTAB process to try and create some balance and fairness and make sure that the due process afforded by the new inter-parties review process is something that's fair and equitable for everyone. And so, you know, we look forward to more evolution in this area where patent holders' rights, which have been very profoundly impacted by patent reform since 2012, will be a continuing issue for the Fed Circuit to weigh in on and create a more favorable climate for patent holders' rights.